All right, my name is Daniel Sigler, and this is the presentation on current legal and ethical issues in education for IL 564. Starting this one off, we're going to talk about religion in public schools, starting with school prayer. Now, the most important thing on this one is the Establishment Clause, and that was established by the Supreme Court. It basically says separation of church and state. The school is a function of the state, so the school cannot endorse a church or a religious view or anything really specifically religious. The government cannot aid any religion, and that's where it applies to schools. In Engel versus Vitale, 1963, the Supreme Court ruled that school-sponsored prayer in schools is illegal. Now, student-initiated prayer in schools is legal, but school-sponsored prayer, faculty member, or a principal, or someone that works for the school in any capacity cannot initiate or coerce or convince a student to pray. If a student's going to pray, it has to be student-led and voluntary. It also, if they want to pray during class, that's okay, but they cannot disrupt class. If it becomes a material disruption in class, it can be stopped. School-sponsored Bible reading is illegal. However, it can be used as an instructional tool for a secular purpose, as like a historical document or a historical text. But some schools stay away from that because that's really hard to do. Some have had trouble doing that without getting into the religious part of it. Also, school-led prayer or invocation at school events is illegal. However, if it is voluntarily led by a student, it is legal. They cannot be encouraged to do it by a faculty member. If we were going to have a football game and a student's going to pray before the game on a loudspeaker, they can't do that if a faculty member asked them to. But if they came to them and said they wanted to do it, then it would be okay. When it comes to displays and religious symbols in schools, schools may not display religious exhibits. If a school wanted to do this, they would have to do, like a teacher could talk about holidays in all the cultures, in all religious groups, but they cannot focus in on the religious aspect. It has to be a secular purpose. It has to be like you're studying everything. But they cannot just display religious exhibits in a religious manner. 10 Commandments cannot be displayed in schools because if it's tied, it's a religious text. States have been challenging this decision, especially in the South, but the federal courts have ruled that they can't do it. Now, outside groups cannot distribute religious materials at school. However, students can, but they cannot cause disruption to school. If students are doing religious things, as long as it does not disrupt the learning environment, they're going to be okay. And also, the Supreme Court has upheld the under God and the Pledge of Allegiance. But also, students cannot be forced to say the pledge under the freedom of expression. So if you have a student that's refusing to say the pledge in the morning or a ball game, we can't, as a teacher or faculty, we can't make them do that. They have the right to not do that under freedom of expression. Also, when it comes to what is a teacher's religious right in school? School districts cannot deny employment or dismiss teachers based on their religion or their religious backgrounds. Teachers have religious rights, but not during school, not when they have kids or students in the classroom. They cannot practice their religion. Teachers also cannot refuse to teach state-approved curriculum based on their religious objections. For example, if you're teaching something in ancient Egypt and you're teaching about other gods and it goes against your religion, you have to teach that. You cannot say, hey, that's not my religion, I'm not going to do that. You have to do it. The courts have ruled teachers cannot teach what they please. They have to follow the state-approved curriculum. Teachers can engage in religious speech with their colleagues on their breaks. They cannot organize religious activities during school. They can outside of school. And also, teachers cannot wear religious clothing or hats or anything like that if it creates a religious atmosphere, or if it creates the impression that you're trying to put religion on students. Now students, freedom of expression. Students have the First Amendment right. They have all their rights, but their rights are limited in the school environment because school has to function. If they had unlimited rights, school doesn't function. Student protests and demonstrations are considered freedom of expression. Students can protest as long as it's peaceful. If it does not violate school rules, if they do not destroy school property, they're going to be okay. The school can tell, if students will protest, the school can tell them, okay, this is when you can do it and where you can do it. And if they follow what the school tells them to do, they're going to be okay. The courts have ruled if the protest causes a minor disruption, it must be tolerated by school officials. But school officials can stop it if the disruption becomes severe. So if they miss a little bit of class, that's not going to be a big deal. If they're walking out and they're sitting in the parking lot all day, they can be stopped. When it comes to student newspapers, the faculty can be an editor on this, but the students have the final say in publishing. And the courts have also ruled that schools can omit newspaper articles that students have written if it's going to cause a significant disruption. So, search and seizure. Teachers do not need a warrant. They do not even need probable cause. They need something called reasonable suspicion. That means you have an informant, and they know who the informant is. It's a credible source of information. The courts will most likely support the search. School can search any of their properties. There's lockers, desks. When it comes to students' phones, and this is a big issue lately, the courts have ruled when it comes to searching somebody's phone, you're going to need a higher standard. Reasonable suspicion is not going to fly. You're going to need probable cause at minimum, but most likely you're going to need a warrant. For example, if you take up a student's phone for texting, and then you start going through their phone and going through their pictures and all this, looking for something, courts will not support that. Now, strip searches, whenever possible, these need to be avoided because they're the most intrusive search. However, courts will find them, most likely will find them legal if a student potentially possesses something illegal, dangerous, or can harm other students. If the strip search must be performed, it must be performed by someone of the same gender, and it must be in a private setting. Now, due process. Students have due process rights as well. We can't just accuse a student of something, give them a punishment, and not hear their side. They get due process. The school board, your local school board should have a policy where it should be fair, and you should have a fair procedure for the students. School administration should always err on the side of caution, but if it's something severe, I have a list up here. The student should be notified of what they've done. They should have a notice of prior notice of hearing if needed. They need a right to legal counsel. And they need that all the Sixth Amendment rights that someone would normally get if they're accused of a crime and they go into trial. The students are going to be able to get that too. All right. Now, educator liability. Teachers must supervise students. If teachers are supervising students, they're going to be okay. If they're not supervising students, teachers are going to be liable for things that happen. The most common one is negligence. For example, if you've got teachers that are supposed to be on duty after school and they're not on duty and something happens, a fight or something, those teachers can be held liable for what's happened. If the teachers are out there supervising and it happens, they're not going to be found negligent. There's a term called foreseeability. If a teacher believes something is going to happen to a student and they foresee it and they don't let anyone know, they can be held liable for that. Like if there's going to be a fight after school at the railroad tracks and teachers know that and don't say anything about it and students get injured, they can be held liable for that. Teachers should properly monitor use by technology from students. For example, if you've got somebody being cyberbullied or students are sexting and you know about that, you don't say anything, you can be held liable. Teachers should always, when it comes to personal information, it's really easy to get a hold of this. They should never give that out to anyone that's not properly certified as a school official. This was interesting too. I learned this during this course. If you're a coach of a sport and you do not properly train your players on how to perform things in the sport, I read an article about a hockey coach who did not teach students how to block a puck. And one player tried to block a puck the wrong way with their face and knocked out most of their teeth. That coach was held liable because they did not teach their student or their players how to block a puck. But had they have taught the students the proper techniques, they would be held liable. This could be in football. You don't teach your kids how to tackle. Somebody breaks their neck, tackle the wrong way, you can be held liable. But teachers should always teach the best of their ability. If not, they can be held liable for something called educational malpractice. If I show movies every day and my students get no instruction and they're not prepared, I can be liable for educational malpractice. When it comes to student records, FERPA, Federal Education Rights and Privacy Act, this maintains confidentiality of student records. There's a lot of personal information or a lot of student information that cannot be released unless the parents consent to that. If the student's 18 years old or goes to a post-secondary institution, they can have that. They don't need parental consent for their records to be released. Parents can inspect the child's record. They can challenge what's in there, and there are guidelines for that. Teachers can view records, but there has to be a notation of what they were viewing, when they did it. And lately, student records are going from paper to being on computers. If that happens, it makes it easier to access, but they still must be confidential. Right. Individuals with disabilities. There's a great deal of legislation that's been passed for individuals with disabilities. For the most important thing, students are entitled to a free and appropriate public education until they're 21. If they have, if they're mental retardation, if they have mental issues, if they're developmentally disabled, is the more proper term today, they're entitled to education until they're 21. There's a term called functional exclusion, where if you have a disabled child and they are placed inappropriately within the school setting and denied of that appropriate education, the school can be held liable. And so the best thing to do, talking with some special ed people here, the best thing to do is do what the parents want. The parents want this child in a regular classroom, in a special ed classroom, in a life skills classroom. Do what the parents want. Your liability decreases in that situation if you follow what the parents want. An IEP, most of us know this already, but that's an individual education plan that has to be followed for special ed students. There's a term called least restrictive environment. We want to put students in the best placement for them, in the most appropriate educational setting. So we want them to be in a setting where they can learn and be nurtured in the least restrictive environment is where we want them. And also the districts must provide reasonable accommodations for disabled students. If you got a student that can't really see well, you might have to buy large Braille textbooks. It may cost a lot of money. That's on the district to do. If you have a physically handicapped child, and you have 2 stories, you got to have an elevator. That's going to be, the school has to do that. Right. And lastly, there's 9 standards, the Alabama Educator Code of Ethics that has 9 standards that we as educators must follow. Basically, this is how we have to act. If we follow this, we're okay. Professional conduct. Be a professional. Dress professional. Don't dress like students. Don't wear a t-shirt and flip-flops. Dress professional. Look the part. Trustworthiness. Use honesty and integrity in your classroom. Do not falsify data or your absences, or I signed in at 7 o'clock when I signed in at 8:30. That you need to be trustworthy. Unlawful acts, follow the law. This is surprisingly, you would think this wouldn't be as much of a problem as it is. But if you, as a teacher, if you get in trouble with the law, you're on the front page automatically. It makes the school look bad, and also it makes you look bad, obviously, but it makes the school look bad too in the district. Teacher-student relationships, have a professional relationship with students. Teachers are mentors for students, so we need to honor our end of the bargain. Do not commit child abuse, inappropriate messaging or sexualized that stuff's you're gonna lose your license, you're gonna go to jail. And also, do not provide students with any illegal things, such as alcohol, drugs, cigarettes, anything like that. Common sense things. Alcohol, drug, and tobacco use or possession. If you want to drink, do it at home. Don't do it. Don't come to school impaired. Do not possess illegal drugs. Do not use alcohol, tobacco at school events. That you'll lose your license over that very easily, very quickly. Public funds and property, number 6. If you have public funds, be honest and respectful with them. That's public money, and you want to maximize the effect of school funds. Do not, mix your school funds, your personal funds, or spend school money on your personal things, because you will get in trouble for that as well. Remunerative conduct, use integrity with everybody you deal with, students, colleagues, parents. When it comes to accepting gifts, gratitudes, extra money on the side, you do not use your job for personal gain. Do not give students extra credit for money, things like that. Just follow your moral turpitude. We know this one right here. You know what's right or wrong. Do what's right. Maintaining confidentiality when it comes to records. Keep that information private for students. Do not use it in ways to harm students. And the last one, abandonment of contract. You have a contract as a teacher. Follow that contract. Fulfill the obligations. Do not abandon that contract without being released to that contract. Right? And if you do not do that, you have your certificate revoked. So, does anyone have any questions about any of these or comments? All right. This concludes this presentation.